Hi guys, welcome back to Nairobi Legal. In the previous video we talked about offers. We had an exam strategy to answering a question on offers, and so for today's video I want us to move on to the next element of a valid contract, which is acceptance. And I want us to understand what does acceptance mean as far as making contracts is concerned. Now the first thing that we discussed is that one person makes the offer that has to be accepted. We talked about an offerer and an offeree, and we said that an offerer makes the offer while the offeree accepts or rejects the offer. And so as far as contracts are concerned, remember that the offeree must say or do something that indicate that he or she has accepted an offer. So acceptance, what we mean is that when someone actually, if two parties are involved in a business transactions and one has made an offer maybe to buy a car, the other person has to accept that offer. This is basically what acceptance is about. And you need to appreciate that there must be an offer and acceptance for formation of a legally binding contract, considering the other elements of a valid contract being in the picture. And this was brought out clearly in the case of Vincent versus Diamond Shield, which we also discussed in the earlier videos on the law of contracts within the Republic of Kenya. Now you need also to appreciate as a student of contract law that acceptance must be unconditional and correspond to the strict terms of the offer, meaning that anything less will amount to a counter offer. And in the previous video still we discussed what a counter offer means. And basically what I mean is that if someone is selling to you a laptop at 10,000, an example, Patrick is selling a laptop to Jen at 10,000, but Jen responds by saying I'll buy the laptop at 4,000. Now that response becomes a counter offer, meaning that acceptance has not taken place in that case. And so remember that every time we have an offer and acceptance in place, this gives rise to an agreement between two parties. So the next key thing you need to appreciate is that when it comes to acceptance, the offeree is responsible for ensuring that acceptance is communicated to the offerer. So if person A, the offerer, is selling a phone to person B, then in this case, if person B accepts this offer at a specific price to take that phone, person B must actually communicate to person A that they have accepted that offer. In fact, we need also to appreciate that there are certain circumstances where there is a specific method or a manner that will be taken into consideration for acceptance to be considered. An example would be that person B person A could say, I would assume that you've accepted my offer for the phone I'm trying to sell to you when you respond to me through an email. The other example would be that for you to accept the offer for my phone, then in that case you must actually come and we agree in person, or by Thursday midday. If you've not responded to me, then I'll assume that you've accepted the offer for this phone I'm trying to sell to you as person A. So remember that there are certain methods of acceptance that could be set out as you enter into this transaction. And as a contract law student, you also need to appreciate that if the offer does not specify any type of acceptance, then in this case the offeree may accept in any reasonable manner and method. Remember that as far as acceptance is concerned, and acceptance could be oral, it could be written, it could also be implied through conduct, through electronic communication, meaning someone sends an email saying I accept the offer you presented to me. And remember that the matching acceptance must be communicated to the offerer in order to be effective. And so the takeout point here is that if two people involved in a business transaction, person A and B are involved in a business transaction, using the example I used earlier, person A is selling a phone to person B. If they have stated certain terms that will amount, or methods that will amount to acceptance, then person B has to comply to those terms. However, if there is no specific type of acceptance that has been stated during this conversation between person A and B, then in that case the offeree may accept in any reasonable manner or method. And like I've said, acceptance could be oral, it could be written. You could send an email and say, I accept your offer for selling to me your phone at 10,000 and I will buy the phone. So this is what we mean by someone placing an offer and the other person accepting it. And like we've said, the matching acceptance must be communicated to the offerer in order to be effective, meaning that you must communicate for sure. You offer to me this phone at 10,000 and I accept that I'll buy it at 10,000. That communication has to be there. In light of the previous slide, we need to appreciate that most litigation, by litigation what I mean is that most cases you'll find in court concerning offers and acceptance as far as contracts are concerned will come from lack of clarity on part of people negotiating a contract. And so remember that any time you're negotiating a contract, you need to be clear about what will amount to acceptance, so that you avoid a situation whereby you're going to end up in court as a result of two people having not understood what actually they were discussing or trying to agree about. So one needs to know, when does acceptance take place? Has it been communicated? So that you actually avoid ending up in court and spending a lot of money as far as contracts are concerned. Now, this is an exam strategy and more of an overview of the previous video on offers and the current video on acceptance. And you need to remember up to this point as a contract law student that parties can form a contract only if they have meeting of minds. And remember that a meeting of minds requires that parties understand each other and show that they intend to reach an agreement. So we need to appreciate that where there is no meeting of minds, you can't actually have an agreement. People must have that intention as they negotiate a contract for them to actually end up having a valid existing contract. Now, this is more of an explanation for the previous video, and so is this explanation that you can consider reading through just to refresh your mind as far as the previous video was concerned. So this is the takeout point. Parties to a contract must have meeting of mind if one is to actually have a valid contract existing. Now, putting this aside, I want to give you a question to prove that you can actually apply your knowledge as far as acceptance is concerned. Now, this question, as you can see on your screen, I'll read through it so that we are on the same page. Now, imagine Omondi is selling his iPhone 11. Yeah, he sends mine an email offering to sell an iPhone for 90,000, and Minor immediately responds back to him offering to buy the phone at 29,000. Remember, Omondi was selling the iPhone 11 at 90,000. Minor's response is that of being able to buy that phone at 29,000. Remember, in this case, Minor hears nothing from Omondi, and so 4 hours later, Minor stops over, or rather passes over by Omondi's hostel, where she learns that Omondi just sold the iPhone to his best friend Jen for 17,000. And in this case, you might wonder, can actually Minor sue Omondi, and what would be the likely outcome of this case? Because Omondi made an offer to sell his phone at 90,000. Minor responds by saying she'll buy that exact phone at 29,000, but Omondi goes ahead to actually sell that phone even cheaper than what Minor had proposed to buy the phone, without actually telling Minor about this new sale. So the strategy here is that we need to remember that a valid contract requires definite offer and acceptance. Remember that a valid contract requires definite offer and acceptance. Remember, in this particular case, Omondi made a valid offer, which was selling the iPhone 11 at 90,000. And when Minor said she would buy the iPhone 11 for a low amount, that was non-acceptance. Remember what we said? By Minor responding and saying that she will buy the phone at 29,000, that becomes a counter offer. It takes away acceptance from the phone. Remember, the offer was for 90,000, and by minor saying I'll buy that phone at 29, that is a counter offer. And so in this case the question is, was there acceptance, and if not, what was it? It is exactly a counter offer like I've stated earlier, and the result here is that minor made a counter offer of 29,000. And remember, a counter offer is a rejection. This takes you back to the previous video. We said a counter offer is a rejection. Remember, the phone was 90,000. Minor says I'll buy the phone at 29. That means she has rejected the offer of 90,000, yeah, by saying she'll buy the phone at 29. So a counter offer is a rejection, and in this case minor rejected Omondi's offer, and therefore remember that the offer that was made by minor to buy, or rather the counter offer of buying the phone at a lower price, was a rejection, yeah, meaning that Omondi was under no obligation now to sell the phone to minor at any price, and that's why he went ahead to sell the phone. And in this case, when a minor sues, remember that Omondi will win this case, yeah. The takeout point here is that a counter offer is a rejection. The offer was 90,000, buy my phone at 90,000. By responding that I'll buy the phone at 29,000, that is a counter offer, which is a rejection, yeah, meaning that Omondi is not under any obligation to sell that phone to minor, and Omondi had the right to sell even the phone at a cheaper price to his best friend called Jen. This is still an overview of the topic of acceptance, and remember we mentioned earlier that you can be deemed to have accepted an offer through your conduct. An example would be that if Njoroge lost his puppy, and Njoroge goes ahead to place an offer to reward anyone who returns that puppy safely to him. Remember, returning that puppy will be deemed as acceptance. The fact that a person actually goes out there to look for this puppy and return it to Njoroge, that will be acceptance of the offer that Njoroge made. Maybe Njoroge said, I will pay 5,000 to whoever returns that puppy. So the conduct of bringing that puppy back to Njoroge by whoever finds it, wherever it is, that will be called acceptance to the offer that Njoroge had made previously. The other thing you need to understand is that as far as silence is concerned, as a general rule, we need to understand that a silence does not amount to acceptance. And if you want to appreciate this further, please consider reading this case. Also, as a contract law student, you must be in a position to understand and explain the rules of acceptance. And remember, in the previous video, I referred you back to this case again. Consider reading the case so that you understand. And just to break this down for you, acceptance must match the offer, meaning that in the previous question we said if Omondi was selling the iPhone 11 at 90,000, the acceptance must match that offer, meaning that minor must respond by saying yes, I will buy that phone, iPhone 11, at 90,000. So remember, one of the rules of acceptance is that acceptance must match the offer. The other thing you need to appreciate is that for acceptance to be effective, it must be communicated to the offerer, meaning that for this acceptance to be effective, taking you back to the previous question, minor must again communicate to Omondi. Next is that acceptance may be oral, may be written, implied from conduct of the offeree, meaning that you could accept through speaking to someone, sending them an email, or even through your conduct, like I've explained through the story of Njoroge's lost puppy. Now, the other thing we need to appreciate again is that the offeree must have been aware of and intended to accept the offer. Taking you back to the question of iPhone 11 between Omondi and minor, remember in this case minor must have intended to accept that offer, yeah. But in this case, remember, like we said, based on these rules, acceptance must match the offer, meaning that assuming that minor responded, she had the intention now to buy that phone at 90,000, just like the way Omondi had suggested, then in that case that intention must be clear, that minor accepts to take the iPhone 11. The other thing we need to appreciate is that the offeree must accept the offer in its terms, any variations or modifications becomes a counter offer. Remember why I said a minor will lose the case and Omondi would win? Because Omondi was selling the iPhone 11 at 90,000 and minor responds to that offer by saying she will buy the phone at 29,000. That becomes a variation or modification of the offer that was done by Omondi, and in this case it becomes a counter offer. And to take you back, as explained in the previous video, a counter offer is a rejection. Yeah, so I hope you've understood these rules of acceptance. Yeah, read them, appreciate them, put them into practical terms. Yeah. And lastly, as far as conduct is concerned, please consider reading this case so that you're in a position to appreciate that a contract can be accepted by the conduct of the parties. So these are some of the things that you need to understand as you do contract law. We talk about the first element, we talk about the second element. You need to see how these two elements link up so that by the time we're going to the next element of a valid contract, you're able to know how each element is building on each other and how each one of them work together to form a valid contract. Now, this brings us to the end of this video, and I'm sure you've understood the second element of a valid contract. In the next video, we're going to be talking about intention, which is also an element of a valid contract. If you're new here, please remember to subscribe. Thank you.